Section B, suspension of laws. Subsection 1, powers of Supreme Court of Ohio pertaining to unconstitutional laws. The Supreme Court of Ohio shall have the power to suspend, abolish, or vacate any law, rule, regulation, or other governing provision in Ohio deemed by it to be unconstitutional. If any law, rule, regulation, or other governing provision within Ohio is determined to be non-compliant with this Constitution, it shall be deemed null and void and without legal force or effect from its beginning. And all powers and authorities of the state affected thereby shall immediately cease by authority of this Constitution until the constitutional deficiency has been resolved. Such determination shall not be dependent upon any adversity created upon government or any public servant. The resulting decision and subsequent state actions and consequences shall be prominently noticed to the people by the said court. The Supreme Court of Ohio shall retain jurisdiction over such matters until resolved. This is one of the most important provisions of the amendment. It is the duty of the court to protect people from unconstitutional laws and to protect our rights from all stealthy encroachments. Without this protection, the people are vulnerable to the whims of the legislature, who could make any law it wanted unless kept in check. Since unconstitutional laws are null and void, meaning that they are not law at all, then any encroachment of such laws by the state would be an injury to the people in the form of fraud, sedition, misfeasance, and many other crimes. It is only proper that the state should cease enforcement of any law deemed to be unconstitutional, and it is only proper that the court issue a cease and desist order to the state in such instances. The court must interpret the law in favor of the people, and it cannot act prejudicially just because an unconstitutional determination may be adverse to the state or any public office holder. Finally, the people should be notified of their duties as a result of such determination, and the court should maintain jurisdiction over the matter until resolved. Subsection 2, jury nullification. All juries shall be comprised only of Ohio citizens, and in the course of serving in any criminal or civil action in an Ohio court, shall have the right to hear and determine both the facts and the law of the case. And in the event the jury determines that the law presented or applied against the defendant shall serve to an unjust end, the jury shall have the absolute right, without objection or interference from the court, to suspend or nullify the law as applied in such case. Such determination shall require at least a 3/4 vote of the members of the jury in favor of nullification. The judicial or administrative officer in charge of the proceedings shall instruct the jury of its right of nullification of the law in every case before commencement of trial. It is time to restore control of Ohio government back to Ohio citizens. State citizens are not the same as federal citizens, i.e., citizens of the United States. For Ohio to maintain its sovereignty as a state, Ohioans must maintain their proper citizenship status. Ohio courts belong to Ohio citizens. Jury nullification has a long history, and it was included in Ohio's original Constitution. This process was the people's last stand in controlling their laws. It is an extraordinary power, yet it should remain with the people. And once the jury decides to nullify, it is outside the court's power to challenge it. Judges should also remind juries of this right and how it is to be applied in the court. For more information on jury nullification, we highly recommend you obtain and read the booklet entitled The Citizens Rule Book. It is available for download online at www.apfn.org. ohio.org/pdf/citizen.pdf. Subsection 3. Citizen nullification. The citizens of Ohio shall forever retain their sovereign powers of initiative process to suspend, abolish, or vacate any law, resolution, rule, regulation, or other governing provision of Ohio or its political subdivisions. This provision is similar to the process we are currently executing with the Ohio Sovereignty Amendment. Rather than nullifying the law, however, we are creating a constitutional amendment. The power to abolish a bad law should always be retained by the people. It is the people's government, and if that government should become tyrannical or abusive to the people, then the people have the right and duty to step in and correct the situation. Doing it in this manner, at least, is peaceful. We envision this measure being one of nearly last resort after the other options have been exhausted, those options being legislative interaction and constitutional challenge. Section C. Governmental compliance and accountability. Subsection 1. Non-tolerance of governmental misconduct. Ohio government shall not tolerate any misconduct by any public servant while in the performance of its public duties and responsibilities. Activities intentionally perpetrated by public servants in opposition to the provisions, purposes, and intent of this Constitution shall be considered as high crimes against the people and prosecuted as such by the Ohio Attorney General. The Ohio Sovereignty Amendment sets up enforcement of the Constitution two ways, the first being internal by public officers and the second being external by the people. This provision is of the first kind. We propose that violation of the Constitutions by public office holders is a crime against the people and should be punished as such. State officials will be responsible to ensure that their respective departments operate in compliance with the Constitutions. State employees should be trained and monitored so as to reduce any infractions. Subsection 2. Recall of public office holders. Ohio citizens may execute recall procedures against any elected or appointed public office holder whenever they deem it necessary. Recall shall be executed by petition, signed by electors of the relevant political subdivision. The recall provision shall be perfected when a number of qualified signatures equal to or greater than that acquired to place the said public office holder or his appointing official as applicable into office have been properly submitted and verified by the Ohio Secretary of State within 10 days of submittal. Immediately upon said verification, the Secretary of State shall notify the local sheriff, who shall then order, remove, and bar said public office holder from public office by authority of the Ohio citizens. It was understood in the making of the federal Constitution that public office holders who violate the trust of the people should be removed from office, either by impeachment or directly by the people. 18 states currently have a recall process, and Ohio is not one of them. We propose a simple process using petition vote as opposed to calling a special election. This would save the state money and leave the process in the control of the people. The recall process is another extraordinary power that belongs to the citizens. Its use should be based on just cause, such as misrepresentation, abuse of office, gross negligence, incompetence, or some criminal action perpetrated by the office holder. And once verified by the Secretary of State, it is immediate. This power is not to be used except by the people as a result of their dissatisfaction with the office holder. It is not to be used for political advantage or maneuvering by any political party or special interest group. Subsection 3, filling vacancies after recall, forfeiture of state benefits. The vacancy created by recall of a public office holder shall be filled as soon as practical by appointment from the governor from candidates nominated by the citizens of the relevant political subdivision. In the event that the governor is recalled, the lieutenant governor shall fulfill the duties of the governor. Any public office holder recalled or otherwise compelled from office as a result of unlawful behavior or gross negligence shall be barred from all future service as a public servant in Ohio and shall forfeit all state benefits. Recall is final, without recourse or immunity from liability. If the recall process is used to remove a public office holder from office, the people need to have someone in mind to replace them with. The replacement candidates would be nominated by the people, and the governor would choose one of them to complete the term of the recalled office holder. If the governor is the public office holder being recalled, then the lieutenant governor would fill the duties of governor in choosing the candidate. Ohioans should not have to tolerate the continued support of any public office holder who has violated their office. Therefore, all state benefits shall be forfeited by any public office holder who is removed from office as a result of recall or other misconduct. Once the recall process has been successfully completed, it is final. Some have recognized the severity of this provision. We believe that under such conditions, public office holders will most likely comply with their oaths of office and strive to ensure the integrity of their service to the people. Aggressive? Yes, but fair to the people. We are finally saying enough is enough. Subsection 4, immunity and punishment regarding constitutional violations. No public servant shall be immune from recall, prosecution, or punishment for participation in activities perpetrated in violation of the provisions, purposes, or intent of this Constitution. Said punishments shall be according to law and in proportion to the violation. No public servant shall be immune from the wrath of the people, or from justice of the courts if they betray the trust of the people or violate the law. The General Assembly makes laws that punish the people for misconduct, and the same should apply to public servants who violate their public duties. Punishment should be in proportion to the severity of the offense, and for severe violations, the punishments could include prison or may be worse. Subsection 5, duty of public servants, violation of oath. All public servants shall faithfully, diligently, and prudently perform their respective public duties and responsibilities, and they are required to answer all legitimate grievances and reasonable inquiries pertaining to the duties and performance of their respective offices, and shall faithfully produce such specific public records in their care, control, or ready access as requested and appropriate. Those violating their oath to support this Constitution shall be subject to penalty according to law. This provision addresses all public servants and mandates that they must fulfill certain obligations to the people. Often, inquiries to our public servants go unanswered, and they routinely violate their oaths of office in performance of their duties. It should also help to reduce government waste.